like to introduce our resource person for today's session, Dr. Kokila Konasinghe, who is a senior lecturer of Faculty of Law, University of Colombo, and we are very grateful to you, madam, for accepting our invitation. I would like to introduce the moderator for today's session, Sahasra Veerasinghe. Sahasra, the platform is yours.
Thank you so much, Ms. Peradeniya, President of the Environmental Society of the Department of Law, University of Peradeniya. Once again, good evening to you all. I'm Sahasra Veerasinghe from the 19th batch of the Department of Law, and I'll be the moderator of the session today. Once again, a warm welcome to all of you on behalf of the organizing committee of the Environmental Society of Department of Law, University of Peradeniya. It is absolute pleasure to welcome all of you, including Professor Deepika Udagama, the head of the Department of Law, the University of Peradeniya, and Dr. Kalasenaratne, the senior lecturer and the senior treasurer of the Environmental Society of the Department of Law, and all the other lecturers from our department and all the other participants. And also, I would like to warmly welcome and introduce our guest speaker, Dr. Kokila Konasinghe. Thank you so much, ma'am, for taking your valuable time to join with us today. We are about to commence today's webinar on the topic of rights of nature, the future direction of environmental law discourse, a paradigm shift from the right to a clean environment to the rights of nature. The topic will be very interesting, crucial topic, and a timely session. Juridical protection of the rights of nature is steadily emerging in several legal systems and in public discourse. Rights of nature is the idea that nature possesses fundamental rights as just humans do. So, without further delay, let me take this opportunity to introduce Dr. Kokila Konasinghe, attorney at law. Dr. Kokila Konasinghe received her LLB from the University of Colombo and LLM from Erasmus University, Rotterdam, and her PhD from Keele University, United Kingdom. Dr. Kokila Konasinghe is a senior lecturer at the Department of Public and International Law at the Faculty of Law, University of Colombo. She is the founding director of Center for Environmental Law Policy at University of Colombo. She is currently involved in 2 SAARC regional level projects representing Sri Lanka. She is the former director of the International Office of the University of Colombo and the president of the Arts Council of University of Colombo. She was a visiting researcher and a teaching fellow at Erasmus University, Rotterdam in the Netherlands. Her book chapters and research articles have appeared in locally and internationally reputed journals and publications. Saying that, we will move on to the main program. But before that, once again, I render a huge gratitude to our speaker. After the main session, we will having a discussion on question and answer session. If you have any question regarding today's session, please drop them in the Zoom chat. A gentle reminder to all our participants, keep your cameras off and microphones muted. I'm so honored to call upon our speaker, Dr. Kokila Konasinghe. Ma'am, the virtual stage is yours now. Over to you, ma'am.
Thank you so much, Aibowan. This is a very prestigious moment in my life. That is because to connect with the University of Peradeniya, which has a special place in my heart. And in addition to that, I think collaborations and efforts like this towards environmental protection by the younger generation, youth, is very, very important. Also, this invites to all the other legal institutions. So in that sense also, I think this is a worthwhile effort. So I'm very privileged and honored to be a part of it. Thank you for inviting me, Environmental Society, particularly Chaturya and also Dara. Thank you very much for introducing me. And also, I should mention at the beginning that your head of the department, Professor Deepika Udagama, was once my human rights teacher. So when she was in the Faculty of Law, University of Colombo. So with that respect and honor to her, I think this is a great opportunity for me to come to your department and join with your Environmental Society and deliver this guest speech. And also, I say hi to Kalana, who is a friend of mine and a colleague. Thank you very much as a senior treasurer for giving support for this kind of initiative. So with all of that, I would like to move on to this very important regime of environmental law and also a future prospectus internationally, regionally, and nationally, I would say. So let me just share the screen first, and then we will move on to discussion. You can ask me any question at any time, but as the organizers mentioned, that at the end, preferably. Yes, a paradigm shift from human rights to the environment to the rights of nature. Now, this topic itself has a very large, wider scope within environmental law as well as public international law in general, also certain perspectives of human rights law. Now, if I say at the very beginning, not our environment. Now, if I invite you, all of you, to stop saying and thinking and arguing, environment should be protected because it's our environment. I think in many times in our lives, we say our environment. Can we say that? Rights of nature movement is with the opinion we can't, because we do not own it. When something is yours, which means you own it. So with that fundamental basis, I would proceed my lecture. We do not own the nature or the environment, so it's not ours. We are just merely a part of it. Right, so far, how do we connect this human rights right-based approach to environment? The only available option for us human beings was to go through the human rights approach to protection of nature. So in this, so far, there have been two approaches to environmental protection by human beings. One was anthropocentric approach, which says that the human benefits and impact upon human beings are the central of the discussion. So all the decisions, all the environmental standards should focus on human benefits and impact on human beings, right? For example, if you take the climate change regime, international standards are made to cater that purpose. The key element, the central focus of the whole legal framework on climate change is based on the human being. And there is another approach that is biocentric. Some say ecocentric. So this ecocentric approach takes the wider approach. So it includes all the other phenomena of the nature as well. When we take a decision on environmental standards, laws, regulations, we make those laws, we make those regulations taken into account the whole global sphere, whole ecosystem, not particularly what benefits human have and what impacts on human beings. So it goes beyond that approach, ecocentrism. Now, if you look at that, how it has been happening so far, there have been two methods of protecting the nature through human rights. All across the world, in different constitutions, in different statutes, acts, and also judicial review, we see in different jurisdictions, there have been two methods of protecting nature through human rights discourse. These two methods are, first one, constitutional guarantee for a separate right to clean and healthy environment, like in South Africa, like in Ecuador, like in South Korea. They have, like in Brazil, in the constitution, they have a separate right to, can be on different themes in scope, can be a right to clean environment, can be right to healthy environment, can be right to ecologically balanced environment, like in South Korea. So likewise, they have a separate right to environment. The second method has been greening the existing fundamental right. Now, if you want to argue some environmental pollution case and you see that many humans are being affected by that environmental pollution, so you come up with freedom from torture, inhuman, degrading treatment or punishment. If you have to live next to a garbage dumping area by your urban council, and it causes you a lot of stress and also skin irritation and many other kind of diseases. And then you can come up with, under Article 11 of the Constitution of Sri Lanka, you can say, I have right to freedom from torture, cruel, inhuman, degrading treatment or punishment. The best example would be, and you all know, right to life in India. Article 21, right to life right to life is guaranteed in the Indian Constitution under Article 21. And then the liberal, creative judiciary, and also activist-minded, I would say, very green activist-minded attorneys at law, and also civil societies, NGOs, and interested parties work towards achieving this right to life extend to include environmental elements within. So we say greening Article 21 of the Indian Constitution to include environmental elements within that provision. So we say right to life doesn't mean just you breathing and breathing out and you are living in this on this earth. It includes so many other important elements of human rights. One such is right to clean water, right to live with dignity, right to life should be guaranteed with health, good health, and also clean water, clean air. The moment that you do not have facilities and the moment that the government do not take enough sufficient actions and facilities, providing facilities to make sure, to guarantee your right to life. Your right to life will be violated. So that was the position in India and many other countries taking so far in guaranteeing, protecting nature through human rights. So there are two methods, having a separate right to environment and also greening the existing fundamental rights. So for those two methods, even in Sri Lanka, if you look at a Pavala case, and also Chunakam power plant case, and also many other cases in Sri Lanka have followed this method. Article 12, right to equality, Article 14, 1G and 1H, lawful occupation and right to shelter, right to movement. Those provisions have been argued in cases that has environmental protection elements. Right. So, so far, there have been 4 basic human rights which are directly affected by the adverse environmental impacts. I have listed down those 4. So these 4 rights, in addition to right to lawful occupation, right to livelihood, and also right to shelter, right to education, right to movement. So those rights also, in addition to these key main 4 rights, right to life, right to environment, right to health, and right to water. In addition to that, there have been many other sub-elements of human rights that have been used to argue for environmental protection. Now, in 1972, there was a very interesting article published in Southern California Law Review. What was the article's title? Should trees have legal standing? Now, forget about 1972, it's been 50 years now, right? 50 years, half of a century. Think about today. If I ask the same question, should trees have legal standing? Or if I may change it a little bit and ask, should rivers have legal standing? Should mountains have legal standing? What would be your response? Some would support, I know most of the crowd audience here would support this element. But at the same time, you would think that what a ridiculous statement was that? What a ridiculous, funny suggestion was that? Very, very unrealistic. Now we are in 2022, and I know that most of the people still believe so. So that is why my most respect goes to Professor Christopher Stone. He published this article, Should Trees Have Standing Toward Legal Rights for Natural Objects, back in 1972. And it coincides with the Stockholm Conference, as you all know, the first global environment conference, the United Nations Conference on Human Environment in 72. So this suggestion, this proposition by Professor Stone was hugely attracted by many environmentalists. And then one such incident was the Sierra Club versus Morton. You all, I think, have heard about this case. And this case was that what happened was Sierra Club is a civil society, public interest organization, and they sued Roger C.B. Morton. He was the Secretary of the Interior in that region, to prevent the Walt Disney Company from building a resort on public land in California. Right? It's a beautiful valley and it's a public land. So the Walt Disney Company was going to build a resort. Now, this public interest organization filed a case. Remember, this was in 1972. Unfortunately, this case was not decided in favor of the public interest organization, because they said that they did not have standing to sue. Now, as we all know, we have heard all over the world in the history that whoever takes the different path, whoever looks a point of view from a different way, different dimension, it stays forever. The perfect example I would take is Lord Buddha or Jesus Christ or whoever that those rebellions who goes against the existing opinions. Those opinions really do matter. If you know Hungary versus Slovakia, Judge Veeramantri's judgment was the dissenting opinion, right? Just like that, Justice William O. Douglas had a dissenting opinion for this case. And that opinion, his argument, was based on Professor Stone's argument. He mentioned that who led to the conferral of standing upon environmental objects to sue for their own preservation. And he supported this Professor Stone's argument and he referred to his article in his judgment. But unfortunately, they lost the case. Not only that, as I told you that if the same question asked, should trees have legal right? The same ridiculous reaction would be there even today. So interestingly, because many law students are joining with us today from many legal institutions, I would like to highlight that during these 1970s, see how they have differences of opinions and how they have expressed. The perfect example is on your screen. There was a poem in 1972 August issue of the American Bar Association Journal. Now, this is what you should learn. We all can have difference of opinions. We should not agree to each and everything others say. We should critically analyze, and then only we should realize that whether we can accept it or not, right? But the interesting thing is that you must respect the same right of the others as well to hold different opinions. Now, this rights of nature argument was not welcomed by many during that time. So the Bar Association Journal, American Bar Association Journal, expressed its displeasure to Justice Douglas' dissenting opinion in Sierra Club versus Morton by a poem. Let me read out the poem. Great mountain peaks of name prestigious will suddenly become litigious. Our brooks will babble in the ports, seeking damages for torts. So see the beautiful way of that they are reacting it with some disapproval of the position that they take. But this is what we should practice. Even if you disagree, you must present it in a most respectful manner and very creative manner as well. So I thought that I should share this with you, this experience, and enrich your lives in the future as lawyers. This is how you should respond to different opinions.
Excuse me, madam.
Yes.
Sorry for the disturbance, madam. Madam, as you are host, we cannot admit all others. Can you remove the waiting room, madam? Just to help, madam.
Oh, right. Okay. Sorry. Yes. I prefer to admit all, so I think they can.
Thank you, madam. Okay,
right. Right. So welcome everyone who joined us late. I'm at the place that we are discussing rights of nature global movement. Now see this whole discussion that inspired in 1972 by Professor Stone's article and then Justice Douglas' statement in dissenting opinion in Sierra Club. And then it moved on with so much of ideas and new thoughts. Now, rights of nature global movement has certain issues that they deal with to promote this idea of rights of nature. One is legal personhood. They require legal personhood for natural objects. Now, there are certain counter arguments as well, which I will come later. Now, for the moment, just understand that these are the positions that they use to require these rights of nature for the natural objects. And also they believe that nature has rights, just as human beings have rights. And they have responsibilities, duties, and obligations too. Because once you say that you have a right, it automatically carries certain amount of responsibilities, duties, and obligations. Now, legal naturehood is the newest concept that is promoted by Rights of Nature global movement. Now, we have this Center for Environmental Law and Policy, CELP, we call it CELP, and we are CELPs as we call ourselves. CELP has some connection with this global movement on rights of nature, and we are working in certain projects, particularly with the Indian group, and they have very interesting programs to promote these ideas: legal personhood, legal naturehood, and also nature has rights, responsibilities, duties. So this whole idea of rights of nature movement is actually one of CELP's first few priorities to establish and within the Sri Lankan society, because this is very new concept. Although this is a new concept, this has been there for 2,500 years in the Sri Lankan history. But we have to make an effort to re-establish and revisit the same concepts, and to see whether the legal discipline can accept these arguments, and how do we incorporate these concepts within the law and legal parameters. So that is actually one of CELP's initiatives. And if any one of you would like to join us, we have the Facebook, CELP Facebook, CELP. And also we have the website and all the other contacts, and it is located in the Faculty of Law, University of Colombo, and we are open to anyone who is interested in joining CELP, because it is possible under the bylaws. We can collaborate with other universities in Sri Lanka as well. So you are most welcome to move forward with us with this global movement on rights of nature. Right. Now, where do we find rights of nature as constitutionally guaranteed, or as some provisions incorporated into legislatures around the world? First, and the best example, I would say, Ecuador Constitution. And they recognized rights of nature in 2008, Article 71. And this right includes right to exist, evolve, protected, and also this constitution has right to environment and right to clean water as well. So therefore, interestingly, this Ecuador constitution reflect many aspects of rights of nature, including human rights to nature. So it's a very interesting interaction between human rights to nature and rights of nature within the same constitutional parameters. Therefore, the judiciary of Ecuador has found it very creative when they interpret this interaction between right to human right human right to environment and also rights of nature within the same constitution. And also, if you look at Bolivia, Bolivian constitution does not recognize expressly right to environment or right of nature, but it recognizes the importance of protecting nature, but it does not constitutionally guarantee it. And in Bolivia, rights of Mother Earth and their protection are set out in 2 statutes. So these 2 statutes are very important to study, whoever study or research in rights of nature. So these 2 statutes that I have mentioned here incorporate many ideas of rights of nature within Bolivia. And in addition to that, in Uganda, there is this National Environment Act, which incorporate rights of nature. And that is a very progressive movement, I would say, because many South African countries are very progressive towards environmental protection standards. So Uganda is pioneering this with their National Environment Act incorporating certain elements of rights of nature. Now let me come to somewhat climax of our discussion. Look at this river. This is River Wanganui. In New Zealand, there had been a battle between Maori indigenous group and the government. So in one way, they call this Bangunai River Settlement Act in 2017 that they are decolonization of their rights, because until then, the government policies depressing the rights of the indigenous community over this environment called Bangunai River, which is very much central to their survival. Now in March 2017, the Te Awa Tupua Bangunai River Claims Settlement Act 2017. Now this is one of the prominent pieces of legislation in the world that declares a river a legal person. So this is considered as a significant progress in the rights of nature debate. Through this grant under this act, this Bangunai River Settlement Act in 2017, river is granted legal personhood, which carries rights, duties, powers, and liabilities, just like any other legal person, right? So this is a landmark in the whole rights of nature debate. And interestingly, they have appointed Maori and indigenous groups to as the guardians of this whole effort. So they can come to court representing River Wanganui, right? So that is a progressive step that was taken by the New Zealand legislatures. And in USA, in spring 2021, a very interesting lawsuit was filed against the state of Florida. For what? For developing a wetland, a housing development project in the Orange County, and it destroys a wetland in that area. So refilling and destroying the waterways, springs, rivers connected to that wetland was the question. So the plaintiffs argue that it will violate rights of waterways. Now, who are the plaintiffs? Plaintiffs are therefore wetlands and water streams, river states, So they have right to exist. So that was the argument. They have right to exist. So this USA case in Florida was once one of the most progressive cases that has ever happened in USA. And that was the first enforcement case on rights of nature in the USA. So now we are eagerly waiting for this judgment, and the plaintiffs are, in this case, according to rights of nature movement, are water streams, rivers, and the wetland. Now, I would like to know how many of you think of something that is going on in Sri Lanka at present with this argument. The same argument can apply to another incident in Sri Lanka. And last week, the writ petition was called and the judgment was given. And they held the progress of the development project in Talangama Elevated Highway. The case was filed by Center for Environmental Justice, and the court declared that the proper EIA has not been carried out for the second phase of this elevated highway. So it's a violation of the law that is mentioned under the National Environment Act, right? So it is quite similar to what is happening in Sri Lanka at the moment, but unfortunately, we have not even reached the position in USA back in 1972, if you forget about 2022. So this is why I thought that when I address the legal institutions in Sri Lanka on any environmental matter, when Chaturya invited me, I told her that we should have this discussion, this presentation on this area, because this is very, very important area. Because similar incidents are taking place, but the similar position is just a dream at the moment. So that is why I invite law students. You are the future generation of lawyers in this country. And it is your responsibility, duty, not just merely Article 28F mentioned that it is your duty as a citizen of this country, not just merely because of that, it is your responsibility as a human being. Right? So this USA case is quite similar to what is happening in Talangama Elevated Highway, and the judgment, the writ application that was filed by Center for Environmental Justice. And this is another interesting case by the neighborhood, and they are always ahead of us when it comes to environmental law and legal judicial review on environmental matters. And these are the two cases that I have mentioned here are High Court judgments. And what happened was the river Ganga and Yamuna were declared as legal persons. So legal personhood was granted for river Yamuna and Ganges. And with all the corresponding rights, duties, liabilities of a living person. And you know that how divine the rivers are recognized in India and in Hindu culture. So that also another supportive issue towards this claim. And however, this rights of nature movement is very strong in India, and with their support, these two cases in Uttarakhand High Court declared river Ganges and Yamuna as legal persons. And there was a different point of view as well. So as law students, you must always look at both sides, because you never know that you may appear to the defensive side as well. So what are the different opinions expressed with regard to this case? That is, this appeal, when the appeal goes to the Supreme Court, there was a counter argument about the legal personhood of river. Now they took a very interesting example, right? The argument was based on, what if a river floods and kills human beings? Can the river holds up in liability for homicide? So that was the argument. Now, this is the whole issue with rights of nature. Because now if you give legal personhood, then it carries certain obligations and rights and duties as well. So can you hold up any natural object like mountain, if it earthside, can you hold the mountain responsible for that? So likewise, this is the thing that we should explore further in our research and find the answer, right? So the Indian Supreme Court overturned the High Court decision. So they did not accept the argument that the High Court put forward. Nature does not really fit within the human legal personhood. So what rights of nature movement advocates suggested in this scenario was that we should move beyond this anthropocentric legal personhood to a position that recognizes the nature's unique place and identity of this whole debate. So we have to invent certain legal parameters and ideas and concepts that nature could fit in, right? We'll see how we do very soon. So the counter arguments and the limitations that you must aware with rights of nature debate is these arguments were particularly relevant to this river Ganges and Yamuna cases, Uttarakhand High Court cases. Now, the first argument was, now whenever the river floods and kills human beings and destroy their property, now can the river shall be liable? Can we argue that the river should compensate the damages, right? That is one argument, very strong argument. And another argument is that in this particular case, this was delivered by Uttarakhand High Court. So therefore, their jurisdictional power was limited to Uttarakhand state. So that was also raised by the defense lawyer. And then, that argument was that what happened a river in Bihar or West Bengal, where it flows. So does this judgment really matter in that scenario? So that was another argument that is unique to this particular two cases. And also, what are the characteristics of those legal rights? Now, when you say that you have legal personhood, then it carries certain characteristics. So here it mentioned that the first characteristic is who is the owner of the right, the subject of the right, the person entitled to that right. Can a river or inanimate object of nature hold this right? Can be the subject of the right. So that was another argument. So I invite all of you to explore further in these directions. And also, there should be an object of this right. So what is the object of this right? Now, when you give legal personhood to the river, does that mean that the water contained in the river and soil underneath its bed, and also biodiversity, fauna and flora within the river also has this right, also share this right, also share this legal personhood, right? So those are the questions, limitations and counter arguments for rights of nature debate. What are the future directions? So how do we move forward with this very valuable and very realistic argument if we want to survive in the future? Legal naturehood instead of legal personhood. So how do we look at this legal personality or legal personhood, the locus standi in the court, from a very broad perspective? Now, this is very difficult for us to do at the moment because we always frame our arguments. We always frame our intellectual capacity anthropocentrically. We always think, so it should be a man or a woman, legal person. So human being. So how do they hold rights? How do they come to, how sometimes people might even think, how can they walk to the court? Because it's very anthropocentric. Our thinking, our directions, our arguments are very anthropocentric. So that is where we have to move beyond our anthropocentric framework and then think beyond that. So rights of nature advocates use this legal personhood because it is what they can fight within the available legal framework. Because the rights of nature advocates do not have any other at the moment. So that is why researchers, legal researchers like you and I, should explore this whole concept further and find some options, different options to use, not just merely legal personhood that is existing within the anthropocentric parameters at the moment. So therefore, the legal system, judicial review, and other legal parameters should rethink and invent a definition that ensures rights and interests of the nature. Right? So that is one thing that we can see as future prospects. And now we are coming to the real grassroots issues, right? Now we are back to the realities, because what are the future prospects? Right, I'm admitting people. There are more and more coming. Right. The future prospects for Sri Lanka. What are the future prospects for Sri Lanka? Now look at my list. My list is not future. My list is present and past. So I have question marks after each incident or each instance, each area. I begin with Vilpattu deforestation, Chunnakam power plant and groundwater pollution, Kalani river water pollution, Express Pearl marine and coastal pollution, Halangama elevated highway and Muthrajavela wetland issue. Now what are these? These are irreversible, irrecoverable, irretrievable, very important environment of this Mother Earth. These do not only belong to Sri Lanka, these belong to the whole, the Mother Earth, right? All these sectors of environment that is territorially located within Sri Lanka, I would call these are common heritage of mankind, because environment is transboundary. The air, the water, the ocean, forest, oxygen coming out of this tropical forest, and everything that is connected to nature is one way or the other is interconnected. Have you watched Avatar, movie Avatar? You will understand how this has been interconnected. So you never can live isolated, live in isolation. That is not possible because everything is interconnected. The nature is a web. So even if you try to live separate from the other phenomena in the ecosystem, that is very short term, right? So movie Avatar explains this beautifully as a great piece of art, cinema. Have you read the Lorax, the novel Lorax? And there is an animated movie as well. It talks about the life of trees and the nature, and how it connects with human beings. And human beings are just merely part of that. As Seattle, the great chief of Red Indian chief, Seattle mentioned, it is just merely one strand of the web. We always forget about the web. We only focus on one strand, that is human beings, right? So Vilpattu deforestation has done a greater destruction to the world. And what would those trees feel? And what their rights? And what is the right of the biodiversity consistent with that Vilpattu forest? Can we grow Vilpattu forest over a year, 2, 10, 50 years to the same level? And Chunakam power plant, a thermal power plant polluted the groundwater. In Jaffna Peninsula, the clean water is divine. It's very, very scarce. And how important the water to be clean in that area, and groundwater polluted. And what is the right of the groundwater? Have you ever thought of that? They have right to not to be polluted. They have right to exist. And Kalani River, the most consumed river of Sri Lanka, that was polluted by a multi-billion multinational beverage company. And what would Kalani River feels about that? And what would Kalani River's rights be? What is the right discourse with, in connection with this pollution of water in Kalani River? Express pearl, marine and coastal pollution case, I do not want even to elaborate on that. The devastating pollution and the ignorance that is connected to that is enormous. It will affect the environmental restoration for generations on this earth. And it caused damage to the most marketable and economically valued, and also for recreational purposes of the people of this country, and also livelihood of people. All were connected with this case. And forget about the human beings part, human right part, right to livelihood, right to recreation of human beings. What about the marine biology and the nature connected to coastal areas of Sri Lanka? That cannot be replaced. And what are their rights? Can we restore that to the same level? And also Talangama elevated road, this and highway road, and then Muthurajavela wetland issue also reiterate the same argument. What would the wetland think about this? What their rights? How can they claim their rights? Right? So these 5 instances or incidents that took place, we can even add a Pavala phosphate mine. What would phosphate mine think? What their rights? Right? So this is the ecocentric approach to environment, and that is why I invite you to just move out of the anthropocentric strict framework of your intellectual capacity and take a different direction towards ensuring environmental right from rights of nature perspective. My final slide, and I include this word hope for 2 reasons. First reason, Sri Lanka is blessed, I would say, blessed with natural resources. And it's a country like heaven with many natural resources. Not only the scenic beauty, I'm saying, economical value, and also cultural heritage value, all of that include my argument. So it is blessed with natural resources. we can utilize them, respecting the rights of the future generations and also rights of nature. So this paradigm shift from the right to clean environment to the rights of nature takes this ecocentric approach. My second reason to use hope is I'm talking to future lawyers, future academics, future researchers, and also future administrators, can be judges, parliamentarians, or whoever in the policymaking seats of this country. So I have a hope. My message today would take you to revisit some of your practices, some of your beliefs, and some of the path that you have been come this far, and make a turn from that and then move towards a somewhat friendly approach to nature. And always think that we are just part of that. We do not have nature. It's not our nature, as I mentioned at the beginning. So with that, I think I conclude my session, and over to you, Dara.
Thank you so much, ma'am, for your valuable thoughts on rights of nature. Obviously, as human beings, we recognize that nature is not mere human property, but instead possesses basic rights. So, ma'am, without further delay, let's move on to the question and answer session. And we have some questions posted into the chat box. So let me repeat the questions for you. The first one is, I think it's a comment. Ma'am, someone has said that in case in India, judiciary decided rivers have rights to life. Would you like to comment on this, ma'am, please?
Yeah. In case, say that again, please.
In a case in India, judiciary decided rivers have rights to life.
Yeah. You mean in Sri Lanka?
In India, ma'am. She has just commented.
Right. Okay. So I think I have referred to those two cases. And also not only in India, I forgot to mention, there is a very important case in Bangladesh as well, where they declared all the rivers in Bangladesh have legal personhood. So many South Asian countries are ahead of us in this application of rights of nature. So India, Bangladesh, they have very progressive judgments. Resha is raising her hand. Shall we go to her question? Because she's going to ask the question.
Resha has commented, has posted that comment also.
Right. Okay. Okay.
And
excuse me.
Yeah, Resha, you can go ahead, please.
Thank you, Dara. Madam, good evening. My name is Rasha. I'm a law student at University of Jaffna. First of all, thank you so much for this wonderful session today, madam. It is extremely useful for me because I'm currently carrying out my final year research project on environmental law, which is specifically about the concept of ecocide and its international criminalization, a critical analysis. So for that, rights of nature gave me a whole different perspective to be included in my research project, madam. So with that regard, regarding ecocide, madam, when I was researching, I was into searching the nexus or the connection between the ecocide and genocide, madam. So in my research, what I found out was the importance or significance we give to the crime of genocide should be equally given to the crime of ecocide as well, because the ecocide should be considered a method or technique used to the consequent genocide. So what do you feel about internationally criminalizing ecocide as a crime under ICC statute, madam, as it is proposed by many scholars? And what impact can it do to rights of nature campaign, madam?
Yes. As I told you, that this right-based approach, whether it is to human right or to rights of nature or ecocide concept, as you mentioned, they are all interconnected, right? So in my opinion, they all are going in the, how do I say, they all are aiming at the same destination. So taking different paths. That's how I see these movements. So the final destination is the same for all of these. So you are very rightly pointed out that the International Criminal Court criminalizing this ecocide, any kind of activities against the ecosystem as ecocide. So that actually taking a different point of view, a different procedure altogether to what we have taken so far. We think that ecosystem or nature is a commodity. So we can utilize. Since the Industrial Revolution, that is what has happened, right? So that is why in Silent Spring, Rachel Carson in her foreword mentioned that we have come this far in a super highway, very comfortable, industrial development. So we think the nature is a commodity. Now, when you pollute this very nature, we think we have right to do that because we can dispose whatever the output of our development freely into the nature. That is why we dispose garbage, chemicals into the water, into the soil, and polluted air into the atmosphere. So we think it's all right, but that's an ecocide. So criminalizing that aspect is another progressive steps that international law has taken towards protecting environment. But how I said, rights of nature, ecocide, and many other aspects of these, many other movements of this nature aims the same destination, but takes different paths, which I think we should encourage. Thank you, Resha, for that question. And also, thank you for doing environmental law research. Keep doing it. If you need any help, any assistance, I am more than willing to help you.
Thank you so much, madam. That is so kind of you.
And Resha, I hope you got the answer. So let's move on to the next question. So I think this is also regarding the thing that ma'am already mentioned. So ma'am, one is asking, how can we maintain the balance between the right of nature and economic development?
That is where we have largely failed at the moment, but we were very successful in ancient kingdoms. Very well balanced economic development with human right to environment as well as rights of nature. And turn back and see how it happened in with Parakrama Samudra and many other incidents, ancient values, and many other development projects that took place in Sri Lanka. Few years, not few years, like few generations back. And how did they do that? It is incomparable to many other countries, and they manage quite well. So to answer your question, we think that it is very difficult at the moment as a country who is sinking in an economic crisis, if I may say. But now, if we take short-term decision solutions, the profit or impact or benefit also will be short-term. Therefore, it should be sustainable. Whatever the decisions, plans we have should be sustainable. And in addition to that, I would answer to your question with 2 examples in environmental law, other than the concepts and principles like sustainable development, precautionary principle, You can use all of these concepts and principles when you make decisions with regard to environmental protection in order to achieve what you just mentioned, to balance economy and human right to environment and rights of nature. In addition to that, there are two main tools that you can use. Environmental impact assessment, the perfect sustainable tool in addressing this, this balance between environment and human right, and environmental protection, social concerns, and also economic development. So nobody would agree that we should stop economy and have a completely green environment. I don't think that is possible. What is possible is integrate environmental concerns into the development projects, as it says in environmental impact assessment. And in addition to that, there is another tool, environmental protection license. There also, the industries are categorized into two, and then according to that, the renewal process is decided. So the industries that have a major impact on environment should renew their license, environmental protection license, annually. So every 12 months, they have to undergo the process, technical assessment by the experts. And then they have to adhere to the conditions that they give. So this way, the Sri Lankan law has provided two best tools to maintain industrial economic development with environmental protection, EIA and EPL, in addition to concepts and principles like precautionary principle, polluter pays principle, sustainable development, public trust doctrine, common but differentiated responsibilities. All of these are also relevant in answering your question. Good question. Thank you.
Thank you so much, ma'am. And there are so many questions posted in the chat box. Would it be okay with you for answering all the questions? Because
yes, I have dedicated my evening for you guys. I told you that as a product of free education of this country, this is an opportunity for me, given that to give it back to the society. So I am more than willing to answer. Select some of the questions that might be common. So select a couple of, let's say, let's select 3 questions first and then try to answer 3 most.
Okay, ma'am. Okay, thank you so much. And the next question is about, can you explain that what happens when nature rights and human rights conflict?
What happens when nature rights, rights of nature and human rights conflict? Yes, I got your question. Now, if I answer to this question from the anthropocentric approach, I would say human rights are priority, should be prioritized. So rights of the human should be protected in the first instance and then look at the environment. But if I take the ecocentric approach, I would say take the rights of nature approach and protect the nature, then ultimately in the long run, humans will be protected, survived. So my simple answer would be, unless you protect and prioritize rights of nature, there's no hope to protect human rights. So my prioritization would be rights of nature, and then ultimately all the human rights will be protected under that umbrella. This is where we made the mistake as human society, community, the global community. Why? Because we make laws, standards, regulations according to the human-centered decision making. Now, that is where we went wrong within the Kyoto Protocol and even some aspects of Paris Agreement with the climate change debate. That is why we continue to battle, or we continue to suffer in terms of commitments by the countries, because we take very much human-centered approach. And the problem has not still been decided or conclusive. So in order to have a sustainable decision, I think when human rights conflicts with rights of nature, I think if you protect rights of nature and if you prioritize rights of nature, human right to environment will automatically be protected. So that is my perception of that question.
So I believe that we got the most thought-provoking answer for that question. And ma'am, let me share another question. This is from our Pumani Konasinghe ma'am. She was once assistant lecturer at our department. And so ma'am is asking, she wants to know your thoughts on sustainable development goals and its impact on RON. There is research on how SDGs contradict the RON due to its heavy anthropocentric view on the environment. Do you think Agenda 2030 inhibits RON?
My understanding of sustainable development is that when human community comes very close to disaster, meeting the disaster at the end, they try every other possible way to survive. That's why we say that so it's like that. Because now we have tried so many sustainable development laws, policies, which were not fruitful, which did not meet the expected outcome, expectations. So this is a kind of another new approach to address the sustainability issues. And also it coincides with 2015 Paris Agreement. So Paris Agreement, Sustainable Development, both were adopted in 2015. So this actually shows the tragic situation that the global community is facing right now. It reflects that alarming situation. Even though we are not very sensible to that, I think that reflects that. So for an environmental researcher like myself, this is no good news, right? This is even worse than Putin attacking Ukraine at the moment. For an environmental researcher like myself, it is even worse and imminent, the climate change threat. However, now, if you look at the question that Pumini asked, that it contradicts, I don't think it contradicts, because if you protect and if you prioritize rights of nature debate, if you take decisions prioritizing nature and looking at the holistic approach to environmental protection, I do not think that would really contradict sustainable development. I think that it complements each other. So I do not think that if humans make decisions according to rights of nature and looking at the ecosystem as a whole, then we may not even need to go for sustainable development goals, because many rights, that is, among the 17 sustainable development goals, many rights would be protected ultimately, as long as we follow rights of nature, rights of nature approach. But at the same time, Pumini, I would agree with you, because it is a very unrealistic and also not real at the moment, because it's a very hard argument to make that rights of nature approach, particularly countries like ours, developing countries. It's a very difficult argument to put forward. And also countries like ours, where very rigid legal judicial review mechanism is operating. So it's a difficult approach, I agree. But I think idealistically, that is the best approach.
Thank you so much, ma'am. And there's two more questions. So the first one is, even though Talangama wetland is recognized as World Heritage under Ramsar Convention and Environmental Protection Area under Gazette issues by CEA, it's subject harms by unlawful construction. The Ministry of Environment has authorized to build the highway through wetlands. Is it lawful?
No, not at all. Not at all, for a couple of reasons. One is that the noise pollution. Once the highway is built, it will cause terrible noise pollution, which is very higher than the accepted decimal level. Second, it will destroy the wetland. And also National Environment Act declared it as an environmental protected areas. You all know that. If you don't know, learn it today. There are certain areas that have been recognized as environmental protected areas. So these areas should be protected beyond any kind of intervention by humans and development process. So under that basis, it is a violation. And also it will be a lot of emission when this highway is built, and when it is functioning, there will be a lot of emission, and it will definitely destroy the biodiversity of this land. Finally, this will violate the right to environment of the present and future generation. Also, under Article 27 of the 14, Sri Lankan government has a responsibility under the directive principles to protect and promote the environmental riches of this country. Wetland is a very important, significant area of environmental sector. So, and also in addition to that, by this gazette, it has been declared as a environmental protected area. So under all these reasons, this is unlawful.
And ma'am, we have the last questions posted in the chat box. How many areas should be covered in a proper EIA process?
It depends on the project that you are conducting EIA for. So the project proponent, the government agency that is carrying out the environmental report, will decide, and all the procedure is explained in the Article 23 of the National Environment Act, 1988 amendment and 2003 amendment. And also, if it is in the coastal area, then Coast Conservation Act has Article 14-16 explains the license procedure. And also Fauna and Flora Protection Ordinance Amendment Act 1993 also carries some provisions with regard to this. So according to all of these laws, EIA should be carried out, and according to the National Environment Act, the project proponent will decide depending on the project that they are doing the EIA for. So if you mean that what you want to know is the procedure, then there is a proper procedure explained in these acts. All three acts have certain perspective of EIA.
Okay, ma'am. I can see only those questions posted in the chat box. So it looks like we have covered all of the questions. Participants, is there anything else you wanted to cover before a wrap up? If you have, you can unmute yourselves or you can put the question into the chat box. So the silent indicates there are no more questions. Once again, thank you so much, ma'am, for answering all those questions and for the comprehensive presentation that you shared with us today. And ma'am, it was truly a great pleasure for us for being with you here today. And finally, before wrapping up this thought-provoking and timely session, I would like to invite Ms. Prarthana Galage, Secretary of the Environmental Society of the Department of Law, to wrap up this session with the vote of thanks. Over to you.
Thank you, Sahasra. A warm and graceful evening to all gathered here. It's my privilege to present the vote of thanks and acknowledge the contribution of those who worked really hard to make this event possible. On behalf of the Environmental Society of Department of Law, University of Peradeniya, its entire fraternity and the organizing committee, I take this opportunity to specially express my deep regards and gratitude to Dr. Kokila Konasinghe, Senior Lecturer at the Department of Public and International Law, Faculty of Law, University of Colombo, and the Founding Director of Center for Environmental Law and Policy at University of Colombo for sparing the valuable time from her busy schedule to grace the occasion as the resource person today. Today, we had an opportunity to hear your thoughts, and this will surely encourage us in all our future endeavors. Your deep and intellectual way of imparting knowledge has added to the glory of this event. We have no words to offer gratitude for your valuable presence here. We are really grateful for your input to make this webinar a success and accept our invitation in such an amiable manner. Again, on behalf of the organizing committee, I would like to extend a hearty vote of thanks to our head of the department, Professor Deepika Udagama, and our beloved lecturer, Mrs. Chetana Karunatilaka, and the senior treasurer of the Environmental Society, Dr. Kalana Senaratne, for providing opportunity to organize such an event and for always being our greatest strength from the beginning. My sincere gratitude also goes to all the other staff members who have accepted our invitation and being here with us today. An event like this cannot happen overnight. It's a pleasure to say that we have been fortunate enough to be backed by a team of very proactive and dedicated office bearers of the society. I am short of words for their involvement and their willingness to take on the completion of this task. My deep sense of appreciation and thanks to all the participants who chose to be with us and attended the webinar with great enthusiasm and made it a successful event. Hope it was a very informative and valuable session for you all. Also, I extend my gratitude to Mr. Rohana Rajpaksha for the technical support given for us. Once again, thank you all for being with us this evening. Have a nice day.
Let me also have 1 minute to express my thanks, because I should appreciate that as university students, you have formed a society, environmental society within your department, which is a great effort initiative. So I should really appreciate, and also Kalana's involvement in that, also Chetana's. And also thank you, Pumini, for joining today. And I look forward to meeting you all in different phases of your life, and whatever the help that I can extend for the improvement of environmental law in this country, I'm more than willing to do. And I'm very proud of you, Chaturya and Audari and all of these guys in the society, and wish you all the very best, and for future research and practice in environmental law. So always stand by the environment, and that will definitely come in return for the benefit of the mankind. So thank you very much. And also my special appreciation and respect goes to Professor Deepika Udagama for her intellectuality and also wisdom in directing Peradeniya legal department into a very inspiring direction, I would say. So thank you very much for joining here today, and it was my pleasure joining here. Thank you so much, everyone.
Thank you so much, ma'am, for your thought-provoking ideas and this session. And I once again thank all the participants and have a nice day. Thank you.